Well, there is a provision in the Bankruptcy Code, Section 523A3, that says that one type of debt that is not dischargeable in bankruptcy is a debt that the debtor didn't list in the bankruptcy papers in time for the creditor to do one or both of two things. Number one, to file an adversary complaint to challenge the discharge of that debt. Number two, to file a proof of claim so that that creditor can get paid by the trustee in the case. So that is the general rule. Now, there is an interesting Ninth Circuit Court of Appeals case called In re Beasley that I think helps to shed some light on this. Beasley, the debtor in this case, filed a Chapter 7 bankruptcy, and Beasley had what's called a no asset Chapter 7, meaning that there were no non-exempt assets for the Chapter 7 trustee appointed to the case to liquidate to have money to pay out to creditors. Well, Beasley got his discharge, and then some months later he realized, oh, I didn't list creditor A, B, C. So Beasley filed a motion to reopen his case so that he could amend his schedules to list that creditor generically ABC. And the court said, sorry, pal, this is not a good reason to reopen the case. So Beasley appealed, and it went all the way up to the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals said the bankruptcy judge was absolutely correct. This is not a good reason to reopen the case, but we're going to explain this so that in the future, debtors know what's going on, why this isn't a good reason. So the Ninth Circuit said in Beasley's case, his case was a no asset case, meaning that there'd be no point in a creditor filing a proof of claim because the Chapter 7 trustee wouldn't be able to liquidate assets and have a pot of money to distribute to the creditors. So the creditor was not prejudiced, at least under this particular factor, in not having been scheduled in the bankruptcy papers. Then the other factor is, could the creditor have filed a non-dischargeability action? Well, the court said that since the complaint has to be filed no later than 60 days after the date first set for the meeting of creditors, amending the schedules would not have done anything to resurrect that 60-day clock. The creditor still wouldn't be able to file that non-dischargeability complaint because the clock had already ticked. That is, if it were a fraud debt, let's say, or a breach of fiduciary debt, or a willful and malicious harm debt. Other types of debts, you can file the adversary after the 60-day window, but for those three, it's a 60-day window. So the court said, if the debt would have been discharged had Beasley listed the debt, then it was discharged. And if it wouldn't have been discharged, let's say it was a student loan, then it wasn't going to be discharged. So as a result, there was no point in allowing Beasley to amend his schedules. Now, in Beasley's case, the debt was determined to be discharged. And I have, on occasion, had clients who, through lack of documentation, even though I get the credit reports, it wasn't on the credit reports, discover that there was a debt that they failed to list. Now, if it's in a Chapter 13, we've got a problem because there the creditor gets to file a proof of claim and participate in the payout. Or if it was an asset Chapter 7 or a Chapter 11, then the creditor really is prejudiced and that debt is not discharged. But if it's a no asset Chapter 7 and it's just a generic, say, credit card or medical debt, then the debt was discharged and that's the end of it. So the long and short of it is you really need to list the debts, especially if there are assets to be liquidated or there's a plan of reorganization through which creditors are being paid. Because if you don't, then the debt will not be discharged. But if it's a no asset Chapter 7, then unless this was a large debt that you incurred 2 weeks before filing where the creditor can say, hey, you never would have been able to get rid of this, then the debt won't be discharged. Now, there's yet another little twist that I used once when I was representing a creditor, and that was the debt hadn't been listed. And so the creditor felt that the debt had been incurred through fraud. Well, the 60-day bar date had already passed by the time the creditor even found out about the bankruptcy case. So we wouldn't have been able to do the adversary proceeding under the fraud exception to discharge. Instead, we used the you didn't list it in the bankruptcy papers exception, and that doesn't have that 60-day window requirement. And so we were able to have a determination of non-dischargeability and sort of bootstrap ourselves into the fraud analysis. But of course, you don't want to do that unless you really do have a very clear argument that it is a fraud debt. And there you're getting a determination of non-dischargeability based on it not having been listed, and that prejudiced the creditor. And so the creditor would have been able to get a dischargeability or non-dischargeability determination. In any event, that is sort of a précis of what goes on in the fraud realm of dischargeability in bankruptcy. But there are lots of twists and turns in that sort of analysis. Again, get a competent bankruptcy attorney to represent you so that you don't make mistakes in this area.